free of trolls. But we're doing, are we live? Yeah, we're live. It's interesting because Facebook changes their rules, and one time the whole recording streaming link disappeared. And then another time they changed it, and it happened on my own personal Facebook page, and that's not what we wanted, but we're here.
We're here. Good morning. Good morning, everyone. As Lisa covers her stress with Facebook once again.
Oh, it's a nasty little devil. Like on my end here, I'm not seeing anything. I'm getting the spinning wheel of death. So
okay, I'll start with the introduction. So good morning, happy Monday, everybody. We are really thrilled today that we have a guest speaker. We have Jeff Smetana. He is the Assistant General Counsel and Director of Compliance and Data Licensing for CRMLS. And as you all saw in the promo piece, he's going to talk to us about Clear Cooperation, what's been going on in the last year, and a few other things. He's got some good information for us. So welcome back, Jeff. Thank you again for being so gracious and coming out and just helping us to educate all the agents who tune in, and we are excited to learn more about what you have to tell us. So thank you for being here.
No problem. Thanks for having me. Okay, so did you have more to add, Lisa, or do you want me to sort of start rambling?
You know what? What's going on at CRMLS? It's been a year with the Clear Cooperation. What's the latest and greatest you can tell us?
Yeah, okay, well, happy to do that. Yeah, we have passed the 1-year anniversary of Clear Cooperation, which became a mandated rule in our rule set May 1st of last year. If you were around during that time and paying attention, you know that CRMLS launched a really comprehensive education campaign starting in January or February, when we sort of developed how we were going to workflow this. I think my compliance team and I did well over 200 trainings on CCP, coming soon and registered, etc., during the year. And as you might also remember, we took a progressive approach. We sort of rolled out the enforcement of this in connection with the education efforts. We didn't want anybody to get really just blown out of the water with a citation on May 2nd or something along those lines. So we launched the education. We did make sure that people understood that we were going to continue that and not necessarily be issuing the citations right away. We wanted to get people on board with it. After a few months, we introduced the full enforcement. We did have a staged process. So in compliance, what we would do is if we got a report that there was off MLS marketing of a property that was not yet obviously in the MLS, we would send an inquiry. And this is not a citation. This was a notice basically saying, hey, we've got this report. You know the rule now. Please put your listing in within 1 business day. We would circle back on that. If it wasn't there, then we would send an official warning, capital W. Now you really need to put this in. And then we'd circle back. And if they didn't, we would issue the citation. That went on for a little while. It was pretty successful. I can tell you that looking back over the year, we have had upwards of 1,000 reports. So these are reports where people send an email to the off MLS marketing at crmls.org. Again, that's off MLS marketing at crmls.org. That's where you send your reports. You need to send us some evidence, obviously, something that we can look at and see what's going on. Maybe it's a photo of the property where you see the sign out front, but it's not in the MLS, right? So we need to see that photo, or it's a flyer or an email blast or anything along those lines. That's where the reports come in. So as I said, we've gotten over 1,000. We've only issued under 50 citations. Okay, so you realize that those are kind of hefty, right? It's 1% of the list price, no less than $500, no more than $2,500. So the good news is the citation rate is fairly low, which means people aren't getting hit with that. The other good news is that out of those reports, everything that we've investigated, well over between 60 and 70% of those listings were corrected. that means they got put into the MLS. So either when we got the report and we looked at it, we looked in the MLS and now the property was in there, all right? Or maybe they responded to our inquiry notice or our warning notice and the property did get put in. Obviously, these people had gotten a couple of days of off MLS marketing, but because of the leniency and the grace period, you know, that was acceptable for us, and we basically wound up seeing a lot of these listings get put in due to clear cooperation. Moving forward, we are continuing to progress the strictness with which we enforce. So as I said, we did away with that first inquiry step. We are now considering removing the warning. All right, I'll let you guys know that CRMLS has a very active rules committee. They're made up of one representative from every association that we service, which is over 40 now. So these are brokers and agents on the rules committee, figuring out, your peers, figuring out how to do this workflow and deal with what's happening out there for you. So this rules committee that we're having this week has a lot of items on the agenda that are related to clear cooperation. We recognize that it's been a year. Let's take a hard look at what we've done and where we're going with this. So one thing we're considering this week is to remove the warning. That means, here's how this will work. If we get a report of off MLS marketing, we're not going to send any communication. You're not going to get an inquiry notice. You're not going to get a warning. We're simply going to take the report, and after one business day, we'll check the MLS. And if the listing has not been entered for cooperation, a citation will go out. Really, the thinking behind this is, guys, it's been a long time. You should understand and know what's going on with this. The intention behind the NAR policy and the rule that accompanies it was to, hey, we can't, this is not acceptable, right? These off MLS pockets, we've got to get them in. So after a year, we're getting to this point where there's really going to be, I wouldn't call it zero tolerance, but really no more heads up, no more you getting away with a couple, 3, 5, 6 days before you have to put it in the MLS. So that's coming up. I don't know what the rules committee is going to do. If they do agree to that, it does have to go to the CRMLS board of directors. And if it gets approved there, it'll become part of our procedure and we will go forward. So that's kind of the big picture. I do have some other things going on with clear cooperation. Do you want any more details on any of the things I've talked about, or do you have any questions you want to throw at me on that particular subject?
Yeah, I have one question. I don't know if there's anything in Facebook, but so let's suppose that the warning is removed. The process is still dependent on agents reporting it to you guys, correct?
That is correct, guys, because we have no way of knowing what's happening out there in the world. We aren't driving around every street in your community looking for signs and are not privy to communications that you might be receiving that constitute public marketing on these listings. So our 100,000 plus agents and brokers out there are part of our compliance team on this aspect, right? We have to rely on you guys to hold your peers accountable, and so it's sort of self-police. We need to know about it from you. Yes.
Thanks.
Okay. Did you have something, Lisa? Well, you're on mute.
Okay, just, noise is going on out here.
Yeah.
So you mentioned ways that agents can report this. Let's talk about that a little bit more, because if they just say, I think this is happening, what is the proof that you want? You mentioned, signs and stuff like that. What are you seeing the most of for the reporting?
Well, the classic example is a sign that's out in front of the property. You've got the brokerage sign with the agent's contact information. You're driving around the neighborhood with your clients or without, or your clients are driving around the neighborhood and they see this and they say, hey, this is great. What's up with this listing? And you maybe go on your mobile app or you go on your desktop and plug into Matrix or your platform and you see, well, I can't find it. Right? Well, in that case, you've got a property that's not in the MLS, it's being publicly marketed. a sign is public marketing. What we need in those situations is a photograph. Pretty simple. We need a readable photo of the sign so we know who it is. And then we really need the front of the property and the address so we can know, like if you just send us a sign and the backdrop is the lawn, we don't know. We know who the agent is, but we don't know where the listing is or the property is, so we can't inquire on that specific basis. So we need a picture of the contact information, the marketing, okay, in whatever context, and then the property itself. The other thing that we get quite a bit of are email blasts, right? So maybe someone has an off MLS listing and they have a mailing list, and or they just decide to go for broke and send it everywhere they can possibly do it. And it's got, hey, I've got a listing that's coming up. Here's the details: 3-bedroom, 2-bath, 1,800 square feet, in wherever, Laguna. That would be fantastic. But we would need a copy of that. So you can simply just forward us that email with your email. We've seen, I'll give you a fun use case here. Let's talk about this. So we've seen some Facebook groups, all right, that are dedicated to marketing of listings that have not gone in the MLS yet. Now, some of these groups we've looked into are not breaking any of the rules. They may do a little bit of marketing, but they get that listing in within 1 business day. That's acceptable. Or they're really just kind of putting their coming soons in there, right? And the coming soons are not subject to clear cooperation because they're in the MLS, all right? They have other issues. We'll talk about that. But we did do a recent investigation of a pretty large group. I won't say the name, but Pockets was in the name, and without revealing too much, we did investigate I think upwards of 30 pieces of marketing. Some of them were okay, all right, and some of them were not, but we did get that. We actually discovered that on our own. Well, it was tipped us, and then we looked into the investigation and proceeded. So it could be any of those things, right? But we have to know about it. We're not patrolling Facebook either. It's a resource issue, but you guys are the ones who are out there. So whatever you get and whatever you're able to take pictures of and give us the examples of, that comes into the report with your email, and we will take it from there. That make sense?
Definitely. Now, when you mentioned, taking a picture of the property and address and sign, does this need to be submitted with the agent's name that's submitting it, or can it be done anonymously?
Well, everything's going to be anonymous ultimately. So, you'll send it to us from whatever email address you want to use. We do like to have a record of the reporting party, capital R, capital P, because we may need to reach out to that person, right? So maybe someone sends us a photo of a sign, let's say, but we don't know where the listing is. We don't know where the property is. They didn't take a picture of the address or give us any other information. So we'll send a responsive email and say, hey, thanks. Can you give us any other evidence on where this property is? So we need to communicate with the reporting parties on many cases. But I will tell you that everything that we do here in compliance is subject to strict confidentiality. So if you are the reporting party, no one's ever going to know that other than my staff. All right. If somewhere down the road there's a citation and then there's a review and an appeal and it goes to a hearing, let's say, before pro standards, we'll keep confidence all the way through the process. Unless you as the reporting party want to join it. Unless you waive the confidentiality and you for whatever reason you need to be involved as a witness or something like that, but that won't come from our end. All right, we will protect the confidential nature of you or the reporting party all the way through.
Okay. Laura, do you have any other questions?
No, not at this time.
All right, let me give you a couple of other things that are happening. These are also kind of specific to the upcoming Rules Committee and some things we're considering here in compliance. We are looking at perhaps adjusting the days on market. Okay, so you might know that in the Matrix platform, the days on market only start at when the property goes to active. However, if you were violating clear cooperation for 2 weeks prior to going active, you might want to look at that and think, well, you had 2 weeks on market and you're going in with 0. All right, is that accurate data? Is that fair? Is that something that perhaps the buyers out there might need to know about? I don't have a strong opinion either way, but I want you to know that we're sort of looking at that. You know, is that the equitable and right thing to do in terms of, again, data accuracy and keeping the playing field level, which are our 2 purposes here in compliance. A couple of other things. You know, sometimes in use cases investigating clear cooperation, we need to ask for the listing agreement. One reason is the Rule 7.9 states that properties subject to exclusive right to sell or seller reserved listing agreements are really the only ones that are, you know, enforceable for clear cooperation purposes. So if we do investigate a report and someone tells us, look, I don't have a listing agreement, I was doing this under some kind of a marketing approach, I don't have the jurisdiction to issue a citation to that person. There have been many cases where we have had to ask for an RLA. And you know, that brings up other issues. Guys, you know what the mandatory submission rule is, which is Rule 7.8. That rule's been around forever, right? Which says within 2 business days of the effective date of your listing agreement, you need to deliver the listing agreement to the MLS, either vis-a-vis an exclusion form or putting it in the MLS. Exclusion form for matrix users have gone away. We now have registered process, but it's the same thing. So in a case where we do get the RLA in investigating a clear cooperation issue, and we discover that not only was there off MLS marketing and there was a violation perhaps of clear cooperation, but maybe also they broke the mandatory submission rule. All right, so you've got a big problem there because, guys, Rule 7.8, which is the mandatory submission rule, carries with it a $2,500 fine, a 1% fine. So we're looking at a use case where someone could get both. That's a big deal, right? So something we need to consider is, you know, how diligent we want to be on that, how the agent community might respond to someone who really should know better, breaking the rules and getting, you know, maybe $5,000 in fines. It's certainly not what we exist for, to issue citations, but these are very important rules, according to the Rules Committee, the Board of Directors, and the practitioners out there who created them. So we're trying to make this enforcement as consistent as possible and as in keeping with the intentions of making these rules as possible. So those are some things that are sort of bubbling under the surface, and you might hear more news about coming up. Again, I can't predict what the Rules Committee will do or what the board will do, but from a compliance perspective, as the Director of Compliance, I'm telling you guys these things so that you know that we're always looking at this. We're always trying to figure out the balance between what the practitioners want and or expect, and then what are the goals of these rules and how do we make that happen.
Exactly. Well, before I lead into the next question or subject or whatever, Lori, do you have anything?
I just wanted to ask, you mentioned the Rules Committee is meeting this week, and then any recommendations would go to the board. When do they meet? And so when, if we hear of any changes, when might we hear some type of announcement of that?
Yeah,
Any ideas?
If I had to forecast that, I think the board meets early July. I think the first or second week of July, and we'll know more at that point. When something changes, so you know how the sausage is made, when something changes and it's a rule change or perhaps a significant policy or enforcement change after the board approves it, you'll get some information being sent out through the AORs. We always provide that information to the AORs. We have a rules change update flyer that we create, an e-connect that goes out, and so that'll all be pre-announced, and depending upon the significance of the change, you know, we might be instructed to give it another 30 days before we actually start enforcing it, right? So again, we want to telegraph this out there. roll it out, and let's make sure as many people as possible, the smart people who read these things,
For the smart people that are here to learn these things.
hey, you guys are even way more out in front.
We prefer the term nerdy.
Oh no, compliance
I like
nerds are my
smart. I'll take
favorite.
smart.
Yeah, well, you know what? I look at it as the folks who attend these things are the people who really are invested in both their professional career, their professionalism, and their industry. Right? This is a fantastic industry, and you have the privilege of being in an industry where you can hold each other accountable and self-police, self-correct. You know, again, I've said it before, but NAR, CAR, the associations, our committees, those are all made up of agents and brokers. So your peers are the ones working this stuff through and working it out and rolling it out for you. It's not coming from the MLS staff. It's not coming from the government. And you know, sometimes there are responses we need to take to the government, but generally speaking, it's an agent and broker controlled industry. So going back to your question, we'll get you an announcement after the board meets and some decisions are made. It'll be a rollout. There'll be comms going out, and we'll give you a hard date as when we are going to start on whatever it is that's been modified or amended or introduced. So I'm thinking maybe in August.
We're going to have to put on a calendar another visit.
That's fine. Yeah, who knows what we'll be talking about.
That's right.
You know, you guys may be over the moon, or you might want to have some other questions like, why didn't this happen or that happen? So yeah, and guys, you know, you can get involved in this process. You know, you're not kept at a significant distance because if you are part of an AOR, your AOR should have an MLS committee. Your AOR has a rules rep, a person who attends these rules meetings. We have had so many rules introduced, corrected, revised because of agent and broker suggestions that bubbled up through the AOR and the rules committee rep. You know, the rep will say, we met our MLS committee, we've talked to some members, we think this particular issue should be thought through by the rules committee. Again, that's not staff generated. So if you want to get involved, there is a process. It shouldn't be too difficult. And, you know, I don't have everybody's AOR rep or rules rep memorized, but your AOR will be able to hook you up and get you involved in the process if that's what you want to do. If you really want to get involved, you could run for a board seat. Okay, that's another discussion, but the board again is brokers and agents. And the elections are generally, I want to say in October, November. So think it through, look alive, get involved.
And it's a good point, a good time to point out that for our area, the association we're a part of, Orange County Realtors, we will have our committee applications be published soon. And I believe those are due maybe in August. So if anyone is interested in applying for our MLS committee, then that's the way to do it. And it would be for the following year. But nonetheless, you could get involved. And Jeff's right. I mean, we've got a very large and good group in our MLS committee, and those conversations they're brilliant. I mean, just the ideas that come forward from that, the different perspectives that a topic is examined through with all of these different people and their different experiences, it makes for a really lively discussion, and it's very thorough.
Yeah.
So I would encourage people, if you are interested, get involved.
Yeah, I applaud OCR. I mean, it's just very, very well run and some really qualified and competent people on those committees. Not to mention the grievance committee and the pro standards committee as well, who are also involved in the compliance process in a different aspect. But I have personally gone and attended those meetings and done trainings, and your folks are on top of it. So good to be involved, but also good for you. Right, you'll be a better agent or broker once you understand that aspect of practice and of the industry.
Absolutely.
Exactly. Well, we're getting a few questions, and I have a couple of things I want to bring up before we get to those questions. I may even intermingle those questions, but let's talk about we're going to bring up the coming soon again, because that's been a real big bone of contention out there. And let's talk the good, the bad, and the ugly about the coming soons.
Fair
Let's
enough.
talk about the good, because I think that there is some good with the coming soons. You know, I'm seeing my clients are all over them. They think it's great. What are the positive things you're hearing about the coming soon aspect that you've heard for the past year?
Well, I think the most immediate benefit is to the listing broker. I mean, because it's an option that you can give your clients that didn't used to exist, right? You've got a listing. It's maybe not 100% ready to meet the world, but your sellers are anxious and they'd like to get some excitement going. They'd like to find out, get some feedback, you know, is our price point right? You know, what kind of interest will this property generate? And so what coming soon was intended to do was to give those brokers, the listing brokers, an opportunity to have their listing in the MLS without getting hit with days on market. I mean, that's really the core of it. However, if we're going to allow you to have a break on DOM, well, it has to be different than an active, right? Because if it's exactly the same as an active, then there's no logical reason why you shouldn't get hit with DOM. So, you know, the key difference is no showings, and it doesn't go out to syndication. But other than that, it behaves just like an active. So we have seen an increase in listings. So in the before coming soon, those listings that weren't ready to go to active would have had to be kept out of the MLS through the exclusion process. You'd have had to send us your CELM or your CRMLS exclusion form, and so nobody knows about it. There's no way to generate any active interest. So we have seen, and I don't have the statistics memorized, but we've seen a lot of new inventory. I know that the bad side of that is it real inventory if I don't get a chance to see it? And, you know, that's the bad, because, I mean, that's the market we're in. It's awful. We all know the inventory is almost non-existent. Would it be better to not have coming soon so that no one even gets excited about something? I don't think so. I think that having more inventory, there are going to be more realistic chances. So again, the good is more inventory, and the good is another option for home sellers. The public is benefiting, the home seller public is benefiting because of this option. I think it is good for buyers, agents, and buyers as well, because as I just explained, more inventory. So getting into the bad, let's talk about that in detail. Why did this coming soon listing go straight to pending? Why didn't it go to active? Right? Isn't that the concept here? You get a few days in coming soon, up to 21 days. Then you start showing it, right? So during the coming soon period, you're taking reservations for showings and so on and so forth. Then your showings start. Then you go through your contract negotiations, et cetera, et cetera. And then it goes into active under contract or pending. The question is, obviously, what happened? Was this listing broker or agent showing this property while it was in coming soon? That seems to be what's on everybody's mind. Or, you know, I know that's what happened. Everybody's very, very certain that happened. Well, let me just kind of roll this out with you. There is a way that you can obviously go into contract during coming soon without showing the listing. You can make your offer subject to inspection, or you send in that offer and it's just way over list. The seller is free to accept it. Once it goes into that status, it goes to pending or active under contract, then showings are allowed. So that's a risk on the part of the listing broker, because if that deal falls through, they don't get to go back to coming soon. Once you leave coming soon, you can't go backwards. Once you go into contract, change the status to active under contract to pending, you're done. You can only go from those statuses back into active or maybe hold or withdrawn, obviously. So there is a way. It is not a certainty that if a coming soon goes from coming soon to pending, that somebody was doing something improper. Maybe just a very aggressive buyer pushed this thing and the seller wanted to go ahead with it. right? So guys, let's just make sure it's not absolutely certain that something improper happened. Do things happen that are improper? Of course. I mean, I have to be a realist here. And the reality is no matter how many rules we make or how many rules you as an industry make, there's always going to be people who break them. If there weren't, I wouldn't need 17 compliance analysts processing 4,600 reports a month. It's a lot. It is a lot. The rules are there. I'm not saying people break them intentionally, but there are people who do. Right? There are people who are always going to break the rules no matter what happens. What should be our response if, and I say our as an industry, as a practice here in California, what do we do about this? Well, this is very similar to the Clear Cooperation reports, guys. Think about it. And here in compliance and at the MLS, we have no way of knowing what's happening out there because it's not information that we can review in the MLS. This is a conduct issue. This is very similar to, we have a rule that says if you're a buyer's agent, you have to accompany your buyers to the showing or to allow them to enter the house. There are some exceptions, but generally speaking, that's conduct. That's a practice issue. We won't know if someone gave their buyer a passcode and sent them on their own unless someone tells us about it. It's the same thing with showing of a coming soon. We've got to have some evidence. I will admit to you, this evidence is hard to get because a lot of times it's just based upon suspicion, right? But we have gotten some reports. We've gotten some marketing pieces that said showings, this Saturday from 1 to 5. And it's in coming soon, right? And we get the report and we have to go into that listing book and say, did you show this property as you indicated? And we are entitled to ask for evidence. So we might ask for the Supra records, all right? Or we might ask them for a written response because that becomes evidence of, and they're basically their testimony. So we do have to investigate these. We've had a couple of situations where we found that some contracts were signed while a property was in coming soon, including things like the AVID, which indicates that the buyer was in the property.
Yeah, that's kind of a sloppy footprint that you've just left there.
Yeah. So guys, I mean, we investigate and we pull in as much evidence as we can, but again, this is a thing where you guys are our compliance officers out there. Our investigators to a great degree.
So let me ask you this on that. Little Miss Buyer's agent and my client sees a house on coming soon, because I've got like Zillow up on my computer right now, just one of the many brokerage sites out there. And I'm looking at a house that says coming soon. Well, they're not syndicated the same way that they used to be because we have a couple of brokerages that are more known for tech than they are for actual real estate. So it's out there. My buyer's seeing it. My buyer says, I want to see this on that date. And you have it all figured out that you're going to get there that date to go see it. And then the next thing you know, it's pending sale. So you wait 30 days, you see what happens. And it's agent A is the listing agent and agent B at a completely other brokerage is the selling agent. Can you say, I want to investigate this? And would they have to be able to produce like a RPA saying subject to inspection or something if somebody challenges that? Or how would that work?
That's exactly right. So when you joined the MLS, you signed your end user license agreement, you agreed to abide by the rules. And one of our rules, several of our rules, give us the right to ask you for documents. And if you don't give us the documents, we have another rule that you can get a citation for not giving us the documents. NAR Code of Ethics, right? Article 14 says you must cooperate with any investigation, pro standards, grievance, MLS. So it's not optional. right? If we want to investigate. And specifically, what can we ask for? We can ask for anything. I just had a case like this, and we asked for the entire RLA and RPA packet. We asked for super records. There are some other things that we're thinking about doing that we need to run through the rules committee and the board that are a little bit even more intense and intentional, things that haven't been done in the past, asking for information that probably people would rather not give, in order to find out what really happened in these situations. You know, again, because the evidence is such a high bar, we have to basically demonstrate that there really was a showing. Right? I can't go in and issue a citation just because we think there was. Now, if the preponderance of the evidence, this is a lawyer's term, it's not, you know, the preponderance is basically kind of 51-49, right? That's the evidentiary standard. It's more likely than not that something happened. The highest bar is beyond a reasonable doubt, right? You guys have heard that in criminal cases. And then there's the clear and convincing proof standard, which is like, call it 75% sure. That's kind of what we're shooting for. If we can get evidence that, in my estimation, is, you know, reaches that clear and convincing proof, I'm comfortable issuing a citation. What will happen then, I predict, is that that agent can file a review request. Right? They can challenge the citation, and as they're perfectly their right. Ultimately, that will end up before a pro standards hearing, which is a hearing, an evidentiary hearing, and it is under oath. So that would be a great situation to really hash this out, to where perhaps I might be able to ask that agent under oath in front of a pro standards committee made up of agents and brokers, you know, just ask them the straight, direct, ultimate question. Did you or did you not show this listing while it was coming soon? That's a lot of work, guys. That's a long process to get to the meat of the heart of the matter and find out what happened. So it's a laborious particular rule to investigate and to prove. That doesn't mean we're not up for it. We're doing it. We just need you guys to be aware that, hey, if you want to report something like this, you got to give us something with meat on the bone that we can look at and really work with. You know, do you have text communications? We've gotten this before as well, just so you know. A text exchange between an agent's assistant and the listing broker's assistant regarding, oh yeah, you can come see it at this particular time when it's incoming soon. Okay, and so we've launched investigations on that basis, but we've got to have something other than suspicion. Make sense? So we're working hard, and we know it's a very inappropriate and unprofessional thing to do. It's a function of this crazy seller's market, which won't always be the case. We will move back to a balanced market, and this temptation to break this rule might not be as great. We have the ability to run reports. For instance, I ran a report about a week ago where we checked everything that went from coming soon into either active under contract or pending that was double-ended. Right. So when you go into pending or active under contract, you have to put in the buyer's agent, right, and the buyer's broker. So we have the ability to look at that and see what the percentage of those are. And I will tell you, it was actually really low. It was very, very low. So if you're a very suspicious person by nature and think, I know those people are double ending those deals, the evidence that I just pulled very recently doesn't indicate that that is the case, generally speaking.
What would you say the percentage is roughly?
Oh, it was basically in line with double ending for actives, right? So anything that went from active to pending, the percentage was, I think it was 10% or lower. And what we found with going from coming soon to pending was the same. So if it was a really dirty trick, you would think that percentage would be higher, right? So active would be at 10%, coming soon 25 or 30, because it's an opportunity to do it that you don't really have, you can't control when you're inactive. So I didn't. I'm telling you these things so you know that way we're looking at these things, and we're always trying to figure out how we can better serve you guys and implement these rules. But FYI, this report did not indicate that there was a staggering difference or any difference at all between the behavior of the coming soons and the actives in that respect.
Yeah, there's some comments, excuse me, in our Facebook Live comments, that people are thinking that it's double-ended. How many of them are same office?
Oh boy, I mean, I don't have, it's a giant Excel spreadsheet. I'd really have to drill down on it, but I don't know. I don't know that would make all the difference, but if I had to answer, I'd say it's probably not that many, frankly, because I know for a fact there's not that many overall. Sorry, that's the only answer I can give without.
No, because that was another question, kind of going on to the ugly aspect is, I had listened in on a conversation regarding being able to show to the same office. And I know the answer, and I confirmed with Sarah that I knew the answer I thought was correct, but a lot of agents don't know what an office is, what constitutes an office when you have a large company out there with the same company name, but there's a gazillion offices and maybe some are franchises, some are corporate. How does that work?
Okay, let me back up a little bit and get a foundational point out there because we're talking about coming soons. And what you're talking about is how to determine if something is an office exclusive. They are two different things. They are two different things. Let me point out and make very clear. In a coming soon status, you can't show that property to anybody. Nobody. Listing broker, buyer's agent, doesn't matter. No showing. There is no application of the concept of office exclusive while you're in coming soon. Office exclusive is a concept that is strictly applicable to off MLS listings. It's a clear cooperation issue. And if you're not catching on, anybody, clear cooperation listings and coming soon listings are radically different, wildly different. Coming soon listings are in the MLS. They're in there for sale. So clear cooperation has nothing to do with it. Clear cooperation only applies to listings that are not in the MLS. So you don't have to think about things like who is the public? What is marketing? Who's in my office? If you're in coming soon, you don't have to think about any of those concepts. They're not applicable. Think of a coming soon this way. It's just like an active listing that you can't show. That's as simple as I can make it. Now, there are some other quirks, right? But generally, if you just remember that, you'll understand what a coming soon is. Office exclusive applies to when you have a listing, you're not putting it in the MLS. Now you know you can't publicly market it. That's what clear cooperation says. However, there is a group of people who are determined or have been determined to be not the public. So you can talk to those people about your listing that is not in the MLS and not break the clear cooperation rules. This is where office exclusive comes in, because the group of people that are not the public under our rules, number one is any clients of the brokerage who have signed an AD form with the broker in the last year. That's not the public. Those are that brokerage's clients. Okay, we recognize the difference. We're trying to draw a bright line here. There are lots of people you might have on your email blast list that you haven't talked to in 15 years. There might be a client that, or a group of people, or I'm sorry, a prospect that you did a deal with 7 years ago, but they're not somebody you're actively working with. On the other hand, you have lots of people who you're trying to get into a transaction with. What do you do in that situation when you're working with someone actively like that? What's the first thing you get in practice? You got to get that AD form signed. That's what the California Civil Code says, right? As soon as you get into a situation where it looks like you're going to be an agent for someone, you need to get that AD form in their hands and you need to get it signed, because that's a consumer specific form that helps them understand what an agent is and what an agent does, right? That's what the state has mandated that for. So you get that. Now you have not the public, you have a client. So we allow at CRMLS those folks to not be considered the public. The other section of folks that are not the public are the other agents in your office. This is where office exclusive becomes applicable. What is an office? Good question, Lisa. Is it everybody who has the same logo on their business card as you in the state of California? No. Is it every other member of a franchise? No. It is only those agents who are under the same managing broker as you. So here's the easiest way to figure that out. If I go on the DRE website and I look up the broker license on your marketing material, there's going to be a list of agents under that broker. That list of people, that's your office. Those folks are not the public. That's what an office exclusive is. So I have an off MLS listing. My sellers don't want it in the MLS. I explained to them this concept. Hey, I can't market this to the public, just so you know. But I can talk about it with the other agents in my office and any of the clients that we have with the brokerage who've signed the AD form in the last year. Those are the parameters. That is the circle of people that you can talk about in your office exclusive work for your listing. That makes sense?
That makes sense. And actually, I learned a little something new on that. So thank you for that.
Yeah, no problem. I know it's a lot.
Well, and it's, a year later, we still have questions coming in. People are still confused. Different people hear different things. And, your explanation right there, it was spot on and needed to be said, because that makes all the difference in the world. And on that note, I'm going to go to the ugly aspect of this, which is, we do have the groups out there that are passing around information. What is safe for somebody to put out there? And I think you already mentioned it once, but we had a few people come on a little bit later here. What is safe to put out to your group of agent friends? And what is not safe to put out there so you will be in proper compliance? Because I think there's a lot of people walking a fine line out there on a lot of things, whether it be marketing, meeting, Facebook groups, closed Facebook groups for listings, whatever groups are out there. I don't know, I'm not part of any group. So what can you do? What can't you do?
Okay, well, let's start with the foundational concept of who, right? And if you stick within the parameters of who, the safe parameters of who, in other words, not the public, you can do whatever you want. All right, so specifically, let's say, here's a hypothetical. You have a brokerage and you have a sales meeting, and the only people attending that meeting or other agents under that broker. Okay, so in other words, there are no members of the public present. At that point, you can talk about or exhibit your off MLS listing however you want to. You can do it verbally, you can make little in-house flyers or send an in-house email, as long as you're not going outside those lines and spilling it over into the public. Same thing with, if you're going to market to potential buyers, they better be clients of your brokerage. They better have that AD form with your broker within the last year. If they do, anything you do in communicating with them is okay. Because again, the main thing you need to understand is who is the public and who is not, because this is a public marketing determinative issue. Or I should say, that's that makes it determinative. The second concept under clear cooperation that's important to understand, and this is what you're kind of, I think, asking about, is what is marketing, right? And we have a long list of what is marketing in Rule 7.9. We tried to think of every example possible. When I do my presentations, I basically say this: you know what marketing is, right? You all do. It's anything that you do to generate interest in this listing or in this property. It doesn't matter if you're sitting in a coffee shop or Starbucks somewhere with 5 people from your, church group or whatever it might be, and you're the agent and you're saying, hey guys, I got this fantastic new property coming on the market that's not in yet. That's marketing. Okay, it could be verbal communication. We have that in the list. It could be something as blatantly obvious as putting your sign out. This happens a lot. So you have to be really careful in a lot of these situations, because we're not making a lot of allowances for, oops, I didn't mean to do that. We had an interesting case where the agent said the sign was out because the seller was washing their car or cleaning out their garage, and they just happened to accidentally set the sign on them. It didn't look like that to me. We had another one where the post was in the ground, and the contractor found the sign in the garage and thought he would do me a favor and hang it up. I'm not going to get into a huge debate on these, but you got to just be careful. You got to be the one who's in control of your listing. It will hold you responsible. Okay. If you say, well, my sign company accidentally came out 3 days early, I don't know what to tell you. If you didn't get it in within 1 business day of that sign, the evidence of the sign coming to us, it's not going to be good. So really lean heavily on who is receiving the information. As long as it's not the public, you can do whatever you want, generally speaking.
And I'd like to ask a clarifying question there. When we talk about office meetings, there are often other attendees. So I'd like you to clarify, when an office invites other agents from other companies as a recruiting, opportunity, come look at how we run our office meetings, that is deemed a member of the public because they don't belong to that brokerage.
Yeah.
And what about affiliates?
Yeah, like your title reps and all of them. Look, if I'm going to apply the rule consistently, you shouldn't be talking about these off MLS listings in front of those people. I'm not trying to make your office meetings less fun, but this is quite serious. And you guys are out there, and and I don't mean this pejoratively, but sneakiness is a specialty of some practitioners. And they'll say, I can imagine a situation, I'm sure you could as well. The title rep gets that flyer or that list or whatever you pass out at that sales meeting, and off they go and hand it off to someone else, and the agent gives them a wink and a nod and says, go for it, let me know if you get any interest. I don't like that happens, but I know it happens, and so I'm telling you, don't do it. If you're running a meeting, make sure that no members of the public are there if you're going to talk about and market off MLS listings, or you'll trigger the rule. Easy for me to say. I would need evidence of something happening to enforce it, but if you asked me that question, that's the answer. That's really the answer.
I think the affiliate part is the piece that a lot of people miss. They think, well, they're not agents, and they're the approved representation that can come into our office, so they don't make that connection. So that's what I want to clarify.
Do they buy homes? I imagine they do.
Yep.
Or they know people who are looking for a home, especially nowadays. How tempting would it be? You're a title rep and you're in an office meeting where there's 50 agents, and they get up and trot out 7 new listings that are coming. And you say, oh, my sister has been looking, and oh man, that's perfect. And so you go to that agent after the fact and say, hey, here's a lead for you. How reasonable is it that would happen? Of course that happens.
And more so with, oh, I know agent X over at 123 brokerage is looking for exactly that, and run over there and tell them that. And also, I think this is an important reminder because, you know, I don't know when the marketing meetings are going to go live again. But one of the really super common things for many of the moderators is, okay, who's got a pocket listing? Who's got pocket listings?
Yeah, I know.
And you know, people need to know, number one, they shouldn't be asking that. And number two, they should be giving parameters for this is what you can talk about here, because, you know, it's so tempting to say, oh my gosh, I got this great new listing coming up. I can't contain myself. And next thing you know, you're blurting it out to the group because all you need is that prompt. And, you know, we need to realize we shouldn't even be bringing up the words pocket listings.
Yeah. It doesn't really necessarily matter. That's definitely not a great term, but I'll stick to my main point that if the only people in that office meeting are the agents in your office, I wouldn't say that that's totally inappropriate, right? You can just say, I feel like I've got this listing coming up. Now, the interesting thing is that if there is no listing agreement in place, Rule 7.9 doesn't even apply yet.
Let's talk about that because we have a question. And I told Inez I would ask it, and I finally get to ask it because she was the first question in.
Go for it.
Is a pocket listing not allowed? Example, agent at X brokerage has a listing not coming soon and shows it to me as a single party show. My buyer likes it and writes an offer. X agent then enters it into the MLS and goes into pending status. Is that allowed? Asking for a friend.
So an SPCA, single party compensation agreement, that's not an exclusive right to sell or a seller reserved listing. So that's not under the scope of CCP. You know, until NAR tells us otherwise, that, you know, we don't enforce on something like that. Same thing with open listings, right? They're specifically excluded from the rule.
Interesting. Good to know, because that was something I didn't know either.
Yeah.
And when I brought up, oh, go ahead, Lori.
I was going to say, let's go back to the marketing meetings, because the marketing meetings are actually, Jeff, usually run by the association or some sort of connection to the association. So it's open to agents from any brokerage. So in that case, sharing it would be a violation.
Yeah, I mean, that would be definitely something where whoever's running that meeting needs to make sure that that's understood.
Yeah, that was exactly what I meant. And Lori, you are reading my mind, because, you know, that is the most common practice. I mean, it's been going on for years, and to get the moderators of these multi-office marketing meetings to not ask for pocket listings is really super important. And also for agents to know you've just did a violation in front of a whole room full of people. So, you know, I think it's really important for us to know once we're back in person, because I think, you know, I haven't been on any of the marketing meetings on Zoom lately, but, you know, I think that when you're in that atmosphere, you're more likely to want to blurt these things out, that more so than an office meeting, you know, because you're in the room with the people that you know would be showing your listings. So
yeah, and I think I want to make a point here also in that let's remember why this rule came about. It wasn't to make people's lives harder. It was really intended to be to a consumer benefit. Okay, you can argue with that, but I think that that's the reality. You know, pocket listing and keeping silos of information and silos of inventory has, in many cases, historically been discriminatory. There are fair housing implications, that concerns that were raised when this rule was being considered. I don't think enough attention was given to that. But in today's environment, and with a lot of the antitrust litigation that's happening, you know, we're included in some of that. We need to be careful, right? We need to be thinking in terms not just what's best for my seller, because what's also being very heavily scrutinized in our industry is what is best for the public? What is best for the general consumer? And it has been concluded, including in one of the court cases we're involved in, that listings being the MLS is what's best for everybody. Now, again, you might disagree. You might have a special seller who wants to exclude. You can do that. You can use an office exclusive. But generally, this isn't to make your life worse. It's basically to say that we've all agreed by being in this MLS, we're going to put our listings in. You know, and if that's not how you want to do business, then you shouldn't be in the MLS. You know, you shouldn't be getting the benefit of the MLS, right? How do you figure out the price for your off MLS listing? Tell me that. You're running comps in the MLS. You're using the data that everybody else has willingly and appropriately put in to benefit yourself at the same time while you're not reciprocating that. And that's not what the MLS is supposed to be like. This is a broker cooperative. That's what you agree. That's why it's called the Clear Cooperation policy. So there are broader issues here. And, you know, this is a great example, talking about these office meetings, of the micro, you know, sort of very myopic vision of someone who just says, you know, I need to do this for me, right? And for my seller. I understand that. But let's remember, we're part of a big, big industry, and there is a big target, you know, on this industry in many respects, from the DOJ and from disruptors and competitors. And it's not an easy time to be NAR right now, or you know, be in that leadership. So I only throw that out there because sometimes a broader perspective helps you remember why we're doing what we're doing here at the MLS, and why NAR is doing what they're doing, and how that affects you, and hopefully makes it a little bit more palatable.
Exactly. And, you know, I think a lot of people are looking at it as, you know, an easier way to get something for maybe one of their buyers. But when you're not putting it out there to everyone, what disservice are you doing to your seller? And there's a house around the corner from me that went coming soon. And all of a sudden it never, you know, went directly into pending. And I saw the price when it closed, and I'm like, they could have got another 25,000, maybe even up to another 50,000 if they would have gone live. Because I'm like, this is not making sense. The comps are supporting a higher price. Why did this person do this? Maybe it was ease of the seller. Maybe the seller didn't want to, but it was already in the coming soon. So they kind of, you know, knew that they were going to go out on the market. But, you know, it's kind of sad to see that seller could have gotten at least 25,000 more for that house if he would have gone onto the open market. So who are you helping?
Yeah, that's a great point. And I will tell you, as an attorney who's involved in a lot of this stuff, that these things are being looked at. You know, there was a rule change that happened this year where we had to remove the searchability by compensation. In other words, you can't search by BAC anymore, because the Department of Justice and NAR entered into a settlement agreement, the gist of which, the underlying concepts when it was meant to address was, we think that you know, agents are steering, you know, and does that include maybe a double ending situation? You know, now double ending is not illegal in the state of California. There's nothing wrong with it under the law, but does it sometimes lead to a situation where that seller didn't get as much as possible? I think we all have seen examples of that. This is not my purview, ethics, right? Your Pro Standards Committee will handle that, but this is a tough job, guys. Again, you're being looked at, but you know what? You're given an opportunity to have a great living and be a professional. So you guys are doing a great job, though, by the way. Just to bring these topics, you know, forward for discussion is very refreshing, and I hope that the people who are watching appreciate that as well.
Well, judging from the comments, they do. And we get a lot of replays too. So it's really nice that we're just a venue to be able to disseminate information that doesn't always get out there like it should.
Yeah, and speaking of information, let me put in the chat, I'm going to paste in 3 links here real quick. Those are links to some of our knowledge base articles, of which we're very proud, and there are dozens and dozens of them, not to mention a ton of other information on our CRMLS.org compliance page website. Videos, slideshows, FAQs, which I've specifically posted here. There is a really cool form. It says registered versus coming soon. It's a comparison chart. Very handy tool. I've also posted the registered FAQs, which is a dedicated FAQ on that subject, and the coming soon FAQs. Having those in hand is a boost. It's a bonus, right? You'll be ahead of your peers in terms of that knowledge. These things include almost all the questions we get. The ginormous compliance general FAQ has grown to 27 pages, but it's comprehensive. So I didn't put that link in there, but that's your homework assignment, is go find that yourself and enjoy your time on our compliance page. You'll be surprised at how much is there for you. So use those as a starting point. And we've got plenty more where that came from if you're interested.
Fantastic. I'm sure we'll go ahead and post these into the group as well in our files, so everybody has handy access to it.
Okay, cool.
Wonderful. Lori, you got anything? Any questions
No.
or comments?
No, he covered a lot, and the resources on the website are just incredible. So thank you for popping them into our chat. We'll get them onto Facebook, but I just always appreciate your willingness to come out and help educate everybody. And I took a page of notes myself, so thank you.
Yeah, I speak for my whole department and CRMLS when I tell you we'd much rather give an education than a citation. That sounds cheesy, but it's true. This isn't about citations. It's about data accuracy at the end of the day and a fair playing field. And we do what we can for that. So, and also remember, if anybody is on here and they really just want to ask a specific question, one of the easiest ways to do that is just to come into our compliance chat. When you go to the compliance page, there's a big fat link that says chat with an analyst. You will chat with not a robot, but an actually trained compliance investigator analyst who will answer your questions. If they can't, your questions will be escalated to a lead or a supervisor, and maybe somehow, some way to Megan or me, and we'll do what we can. So ask and you shall receive. We'll go there.
Wonderful. Well, all I can say is thank you. This has been a very, very, very informative little over an hour, and we'll let you get on with your day, but it was just a wonderful, wonderful conversation. And I know all of our active listeners found this interesting, and to anybody out there, share this information. It's going to live on the Facebook. If we can figure out the crazy Facebook algorithms of how to download our own video content, we'll get it onto YouTube. Always kind of fun out there. But we so appreciate you, Jeff, coming on today, and thank you. And if we have news coming out of this rules committee and it gets approved by the BOD, we'll have you back.
Yes, that's fine. I'd be happy to explain whatever happens or doesn't happen.
We appreciate that.
All right, guys. Thanks for the opportunity. Good luck out there.
Thank you. Okay. Okay, everybody,
Bye, Jeff.
have a good week. We'll see you all later. Go out, sell a house.
See you next week. We're going to cover forms.
New form. Oh, and we might be having a special midweek coffee and compliance, cocktails compliance. Who knows what kind of compliance, but we've got reopening time. So stay tuned to the page, and there may be more Lisa and Lori in your life. Right, Lori?
Wonderful. Happy to be there.
Yep. Okay, guys, have a good one. We'll see you later.
Bye, y'all.